Not giving me a fair shot. Good advice. Who be you? Who shall I give you? Loy, I write the bar and ACU from intimidating a judge to call another discriminatory to spitting on him, former attorney. Much to break down in the triple accused case. Murderer Brice Rhodes trial starting soon. We've got you covered. Introduction to Sidebar from Law and Crime. I'm Jess Weber. A huge trial is coming up in Louisville, Kentucky, as you know. What we do on the Sidebar when we always want to dig deep into significant cases. Deeper analysis of everything you should know before starting the trial of Brice Rambo Rhodes, murderer suspected of 3 individuals. When we know about him. Reporting suggests Rhodes was local. He appeared in rap videos with drug-dealing references. Jump Play With Me lyrics will leave his bleep missing. Rhodes returned in 2016, the pivotal year. The question was whether probation had a domestic attack history. Wave3.com also mentioned that Rhodes was convicted as a sex offender for the incarceration of someone under 18. But he's accused of jumping out on May 4, 2016, car and shooting death Christopher Jones, 40, on the street, according to 15-year-old Annan Carter, who was in the automobile. Wrongly thought Jones' head cost money, meaning he considered Jones a contract killer. Authorities additionally mentioned 2 others, 2 shooting witnesses who were in the automobile, while this. Brothers Larry Ordway, a 14-year-old honor roll student. Brother 16-year-old Maurice Gordon. These brothers were friends. Reports say they admired him. Rhodes also bought them things that were in one of his music videos. But you skip to May 22nd and their remains were recovered in a backyard of an abandoned house. They were beaten, stabbed, burned. Medically examiner found Morris had over a dozen stabs and over 20 Larry's terrible killings. But Mr. Carter supposedly told police everything. He said that happened after a Rhodes home altercation with their brothers chained and stabbed them. They and Carter said he and another Ja'Cory, 17, co-defendant participation was mandatory for Lamont Taylor in the murders. The prosecution claims Rhodes murdered because Morris and Larry were witnesses to Jones's murder and may be worried they'd talk. Carter reportedly informed police. Quotation, Morris cried, and everyone was asked to spare him. Carter claims Rhodes put a rag in Maurice's mouth, the ski mask on his head, and stabbed him repeatedly. Larry was brought out. He was in a bathroom too, and had his face masked and gagged. He was bludgeoned to death afterward. Boys died. Carter claims they put, throwing them in cartons, backyard, and burned their corpses. He and Taylor cleaned up the crime scene at the house. Didn't help since cops reportedly found blood at home. And his automobile also has an alleged witness who may have witnessed someone dumpster match Rhodes' description. They were all burned. Apprehended these guys, and Karen, 19, is the 4th co-defendant. Ultimately, Coleman Carter, Taylor pleaded guilty now. Vaughn Carter informed suspect 2016 was detained. So he said detectives claiming a double murder occurred at my home 763 North Cuyahoga Avenue, apartment 2B. Detectives requested a search warrant. Search my house at 21:18 hours, 22:11 hours. So throughout this search were 5 homicide officers, 1 CSU officer. They spent hours searching. Blue Star chemical solution was used. They looked about the house and looked but found no evidence. A prime officer commented on the apartment's cleanliness and noted that the carpet was clean. Solution, yet nothing was still discovered after applying Blue Star. They cleared the chemical reaction. They left for 1 hour 20 minutes. 1 hour and 20 minutes they returned and researched the house now from 23:56 to 2:14. Quickly claimed blood on. They merely used the same carpet and searched clean. Initially it purportedly had blood on it. Reportedly spit on McLeod. Then, when he moved in court, McLeod formalized his departure. He suggested to the judge that keep clear from Rhodes, saying otherwise we're scrapping. But Cloud has a court conversation with Rhodes. You coward, excellent cheap shot. McLeod says good cheap shot. Rhodes claims you're a coward. I'll see. When I left before he left the court, requested the judge change my bond, reportedly $2 million. Currently at $1 million, but concentrating on. Thoughts on Rhodes and judges saw so much before I got my next court appearance provides some context other than the spitting claims with his ex-attorney. Rhodes spit on a detainee and then accused of beating an inmate. An arrest warrant states threatened to murder him as he did the others. This inmate reportedly injured his forehead and neck. So with everything going on during the hearing, court deputies used rods in wrist and ankle, strapping him to a chair and giving him a spit mask again, and wasn't that impressed. Happy Rhodes, you can just Bring him gear, just like. Said that, and want an attorney to return me. I won't take you anywhere, take you back, but want an attorney, I'll do it. Appointment of public defender office, Miss Shane. That was dangerous. I suppose I'm against the court, requesting the county attorney to consider that, and what to do with that. You heard what he said? He claimed to Judge Amber Wolf was, do you believe we can find out? I don't care where you reside. You have family, I'll be out in charge with more terroristically menacing and intimidating a lawful participant. The case was then moved to another judge, Honorable Judge's courtroom, Charles Cunningham, and throughout Rhodes argued pre-trial that detectives framed him. Requesting representation by another attorney, alleged that his lawyer Thomas Griffiths made racist statements to him, resulted to. This exchange between Rod and Judge Cunningham does your job, not yours. I say worry about me. You worry about me, but not giving me a fair shot good advice. Who do you? Who shall I give you? The lawyer I write Barrow and ACLU you going to discover finding out real quick. I swear that's not even the worst we heard, because at one Cunningham was suspected of having a sexual relationship with a prosecutor. He's also racist. My right to speak what I must on maybe you got some kind of sexual relationship or what I got underway. But I'll tell my man I have no sexual relationship. I mean you and a prosecute over, sir. You ignored me everything if you didn't Deanie. I probably refused the finest motion. Are you racist? Have you had sexual activity? Ongoing relationship, which one is it? Are you incorrect about everything? Motion for are you secret? Not a Ku Clan member, sir. I'm at you, but as mentioned, the higher court will handle things when needed. It appears he flushed the instrument. Toilet before officers could confiscate it was his accusation. Was charged with mischief felony, get away, and tamper with evidence for allegedly threatening an officer jail that would kill him and his family, and that his face would be shanked. Rhodes was charged with terrorism, frightening hunger and danger. He allegedly sent criminal mischief handwritten letters to Mr. Taylor, co-defendant in the same prison as he prosecutors signed. Not Rhodes suggests these writings depict roadways manipulating Taylor's testimony. Taylor confessed and reported Rhodes dead to police because Morris and Larry were Jones' murder witnesses. But back to documents written throughout high on a police statement transcript. Also a letter sent to Taylor claims rats are exposed. Taylor stated Rad slipped him the quote, show me you my exploitative, and unaware of the letter states, quote, between us, as you said, I got the paperwork. So here, exploitative becomes real. Then author Rhodes allegedly orders the Taylor to say to retract his confession. Rhodes allegedly authored Taylor, quote, enjoy no pleasure, they provide you evidence of me. I know, remember they don't have anything on you, focus, adore you, that's significant progress. Kate's but recently discussing Mr. There was another major difficulty, was regarding his trial fitness. This issue delayed many of the trials. There was a backlog of Kentucky correctional cases. The psychiatric center took longer a year for R's case evaluation. How do we discuss competence? We're not discussing insanity. Distinct competence means a criminal defendant's capacity to comprehend and participate in law proceedings. Do they comprehend charges and their rights? And perhaps will you consider everything that we've outlined? May not be unexpected. Competence is a problem. Prosecution stated he's competent. Discuss the court procedure. Judge decides client privilege problems. This matter has been resolved. Julie Callan. She determined that Reyes is competent to stand trial. I don't think that any evidence through testimony Mr. Rhodes is proven today. Isn't just choosing not to don't join his lawyers, consider that necessary causes him inept. No proof exists. Testimony of his incompetence with the trial set to begin comes has its own. Judge Kinn warned Mr. Rhodes about concerns. If he yells during proceedings, he'll have it either delete from the courtroom or ankle-fitted cuff that shocks him. If disrupt proceedings now, to be not wearing the shock cuff that may be an alternative for the if issues arise. So we'll all plan to cover Brice Roadway's trial for you on long crime, 7 years approaching 8, since these killings, many moving parts. And when we describe much that has occurred, all we have between then and today for everyone on the sidebar. Many thanks for joining us. Did you like it? Tell us what you think of the video in the comments section below. And don't forget to subscribe to our YouTube channel for more interesting videos.